This is Las Vegas Real Estate Now with local real estate expert Harvey Blankfeld.
Where we want to educate you about our market, empower you to make wise decisions, and help you engage with our expert contributors. The deed upon death is a something that is kind of unique, and I want to hear a little more about that.
It's a new thing, right?
No, the statute that created the deed upon death Act is an old statute. I believe it originally came out in 2011.
Okay.
But the reason I thought it might be an interesting topic is that we continue to see orders at our title company opened up in which title was acquired by one of these deed upon deaths.
Okay.
And the way it works is that the signer of this deed upon death signs and records a deed naming whoever they want to as grantees. Oftentimes their children.
Sure.
And it doesn't become effective until that grantor's death.
Okay.
And so, this is often promoted as a way to avoid probate,
Right.
and have people.
And does it?
Unfortunately, it doesn't.
I had a feeling.
And that's the problem that I think that people should be aware of.
Mm-hmm.
Now, if you deed the property by a deed upon death to your children, and your children intend to live in the property for a number of years after your passing, then there isn't an issue.
Okay.
Where we run into the problem is where the grantees of the deed upon death want to sell the property or get a loan secured by the property. There's a statute, and it's been there since 2011, but it continues to surprise sellers that we get at least a couple every month.
Right.
Where they find out that there's an 18-month window in which creditors of the deceased person's estate can assert a claim against the house that was transferred by a deed upon death.
If the seller had, before passing, had filed for homestead, does that not protect the property upon the deed changing like this? Or I guess it doesn't. Apparently it doesn't.
No, it doesn't. A lot of times the creditor claims that we're talking about are Medicare benefits.
Oh, okay.
That the deceased grantor received and now owes.
Gotcha.
Back to the state.
Okay.
So, one way to shorten that 18-month period, and it's the way that Equity Title recommends that a seller go when faced with that scenario, is to hire a probate attorney and have a probate opened, which probate would not include that house. That house already passed outside of probate by the deed upon death.
Right.
But anything else that the decedent owned, bank accounts, personal property, furniture, automobiles, things like that, the probate case can be opened, and a creditor's a notice can be given and published in a newspaper for usually a 60-day period.
Mm-hmm.
And that will allow us as the title company to determine whether or not there are any such creditors for the estate.
Yeah, because now they've been given formal notice, step up now or forget
Exactly.
it.
I mean, and that noticing should trigger creditors to come out, and reveal themselves, so to speak, and file their claims in the estate, and then they can be paid, and we can close before that 18-month period.
This has been Las Vegas Real Estate Now. Thanks for listening, and remember to tune in every Saturday at 11 a.m. on 101.5 FM, 720 AM KDWN.